So, good evening, everyone, for joining this webinar. The discussion on the issue abrogation of Article 370 of the Indian Constitution. With us, we have Advocate Shruti Agrawal. She is practicing in Supreme Court and Delhi High Court. And we have another speaker, Kannan. He's also practicing in Supreme Court and Delhi High Court. So without further ado, will this see the we are into discussion as well as debate as well. So हम इसमें first speaker the both speaker will have 15 minutes and 15 minutes to speak for the motion and against the motion. And afterwards there will be 5 minutes and 5 minutes for countering each other arguments. And after which we'll open the platform, open the meeting up for the every participants to have their question asked to the speakers and their opinion expressed as well. So without any further ado, we'll start with Kannan. And Kannan will after just before 15 minutes, we'll have a quick reminder before 2 minutes so that you can conclude your part of. Okay, thank you. So please, Kannan, continue.
Right. Hi. Good evening, ladies and gentlemen. Thank you for joining this session organized by Debate-cum. I thank Debate-cum for this opportunity. And I also thank my colleague speaker today, who's agreed to do this webinar along with me today. Thank you. And it's a very sensitive topic that we are going to speak on today, which is abrogation of Article 370 as it is titled today. Let's first come to the few basic historical facts, very few historical facts, and then we'll come to how this article came to be inserted in the Constitution and what has happened with the operation of this article over the last 65 to 70 years. And what happened in 2019, August 5th, 2019, when the operation of Article 370 of the Constitution was decommissioned. And as a matter of fact, to begin with, I would say that it may not be an entirely correct phrase to use, that Article 370 has been abrogated, because as you would see, the provisions of Article 370 still continues to exist in the Constitution of India. What has in effect happened by virtue of the decision of the government on 5th August 2019 is that by virtue of a presidential order, the provisions of the Indian Constitution have been applied to the state of Jammu and Kashmir in its entirety. And consequent upon this decision, which is a political decision of the government has decided to reorganize the state into Union Territory of Jammu and Kashmir on the one hand, and the Union Territory of Ladakh on the other hand. Let's go to the genesis of what Article 370 is. The Article 370 came to be inserted in the Constitution with the title Temporary Provisions. If I have the article with me, it forms part of Part 21 of the Constitution, which is titled Temporary, Transitional and Special Provisions. And we have Article 369 onwards under Part 21 and Article 370, which says, as its heading, temporary provisions with respect to the state of Jammu and Kashmir. So let us read at the outset Article 370's head note to the heading of Part 21 of the Constitution. Part 21 provides for temporary provisions, transitional provisions and special provisions. And by virtue of the fact that Article 370 starts with temporary provisions, we would have to construe Article 370 to be a temporary provision, which is also forming part of Part 21. And Article 370, Sub-Article 1, Sub-Article 2 provide for how, whether in what manner the provisions of the Constitution would apply in respect of the state of Jammu and Kashmir. And Sub-Article 2 speaks about the concurrence of the government of state prior to the formation of the Constituent Assembly. For the purposes of the present presentation, what is important to note is Sub-Article 3 of Article 370. So Sub-Article 3 starts with a non-obstante clause and states, notwithstanding anything in the foregoing provisions of this article, which is Sub-Article 1 and 2, which says in what manner the provisions of the Constitution were to or not apply in respect of state of Jammu and Kashmir, and Sub-Article 2. Sub-Article 3 says that the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Legally speaking, if you were to read Sub-Article 3 of Article 370, this provision is so special, and I say it with some amount of stress because of the fact that there is no other provision in the Constitution which can cease to be operative by an order or a proclamation made by the President. And as you all know, presidential order or a presidential decree is nothing but the will of the present day government which is elected. So therefore, if Article 370 were not to be temporary in nature, I do not think why the framers would insert such a provision under Article 370 itself, which gives the power to the President to make the article inoperative in its application to state of Jammu and Kashmir. See, and I see one argument, of course, I mean, legally speaking, where the other side could possibly have an argument is the proviso. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. Now, there are three ways that we can read this proviso in the context of 2019-2020. Firstly, that the entire article has become inoperative or has become defunct because there exists no Constituent Assembly today, because as we understand, the Constitution of Jammu and Kashmir came into effect in 1956 after the accession of the state of Jammu and Kashmir to India in October 1947. And of course, the Constituent Assembly was thereafter formed, and the Constitution of Jammu and Kashmir came to be adopted in 1956. And today the Constituent Assembly, because as a Constituent Assembly is beyond the Constitution, so there exists no Constituent Assembly today. So first is that the entire article has become defunct, or we can say that the proviso has become defunct. Or the third way that we can possibly read it is the successor. Now, the Constituent Assembly of India also doesn't exist once the Constitution of India came into force. Similarly, the Constituent Assembly of Jammu and Kashmir does not exist because it has done its job. And the successor to the Constituent Assembly of India is the Parliament of India. And if we were to construe the successor of the Constituent Assembly of Jammu and Kashmir, it would naturally be the Legislative Assembly of the Jammu and Kashmir state. And therefore, the presidential order came to be issued by the President. And ultimately, let us be very clear that I am not speaking this from a political perspective, but I'm keeping it extremely legal to see whether there is any availability of power for the present dispensation to de-operationalize or decommission Article 370. let us read the presidential order issued by the President of India on 5th August 2019. At the outset, it states that all the provisions of the Constitution of India shall apply in relation to the state of Jammu and Kashmir, and the only exception that it is making is the insertion of sub-article 4 in Article 367. And this modification is only to overcome one difficulty that the government had, was the proviso to sub-article 3 of Article 370. So what it does is, apart from the fact that the Constitution of India shall apply to the entirety of the state of Jammu and Kashmir, it says that there shall be inserted sub-article 4 in Article 367. Now, there is one view, of course, against this, that you could not have amended Article 367 in a manner to suit yourself this particular way, which is this particular path that the government has chosen, and you choose to replace the word Constituent Assembly appearing in the proviso to sub-article 3 of Article 370 with the word Governor of Jammu and Kashmir, of course, assisted by the on the aid and advice of the Council of Ministers of the state, of course, which did not exist at that particular moment because the PDP and the BJP government had quit the government some time back, and the assembly had been dissolved by the president, and the president rule was imposed. So, therefore, what, in my opinion, the presidential order does, that is, it, on the one hand, it does apply all the articles, all the clauses of the Constitution of India in respect of the state of Jammu and Kashmir, and it also says that the references to the Constituent Assembly, which does not exist today as on the date of issuance of the presidential order, and the references to such Constituent Assembly shall be the Governor of the state of Jammu and Kashmir, who acts in the aid and advice of the Council of Ministers.
Sorry for interruption, Kannan. There is 3 minutes remaining for the conclusion.
Yeah. So I'll just sum up what my argument is. Question today is, what has happened has happened. Now, the reason why such a drastic move was made by the government without even any notice, if we all recall, when the statutory resolutions which were adopted by the parliament, as also the state's reorganization bill, had no advance notice. None of the opposition members knew about what the government was contemplating. The chair, the speaker, or the vice president of India in respect of the Rajya Sabha had waived all those requirements. So of course, it was extremely surprising for us to wake up to one morning and hear that this is what is the state of Jammu and Kashmir is after the issuance of the presidential order. But one thing we need to examine is there an availability of power with the government of India to enact this presidential order, issue this presidential order, which decommissions or deoperationalizes the effect of Article 370 of the Constitution? In my opinion, it does, because this is the only article which gives the executive government of the day to say that this article shall cease to be operative. And secondly, the fact that the Constituent Assembly referred to in the proviso has ceased to be in existence because of the fact that it has done its job and the Constitution has been adopted, we would have to read that the proviso to sub-article 3 of Article 370 has become defunct. And in any event, to overcome that, appropriate modifications have been issued by the president himself when he has declared that Article 370 shall cease to be operative in respect of Jammu and Kashmir. And thirdly, even when presidential order of 1954 was issued by the president on the advice of the Pandit Nehru government, even then they had adopted this route to apply the constitution in respect of Jammu and Kashmir in the manner which is laid down in the 1954 presidential order. So to sum up, all I would say is that because now it has been done, whatever the political parties may say against rolling back of this decision of the government is quite futile, because the government is not going to do it, and it is one of the reasons that this government has come into power. The only way this could possibly be rolled back is if the Supreme Court were to, in the petitions which are already filed before it, were to hold that this action of the government was unconstitutional. And I have only two reasons, and I will conclude and say that why the Supreme Court is not likely to interfere with what the government has done. Firstly, this is not an issue of, say, fundamental rights or civil liberty, where the Supreme Court would read each and every article and each and every provision of the Constitution so expansively to uphold a question of fundamental right. This is not a question of basic structure because there is no constitutional amendment. And thirdly, because this is nothing but an act of reorganizing the state with the surrounding legal possibilities that you have. The Supreme Court is not likely to interfere in a matter like this. And because we've also seen the reorganization of Andhra Pradesh, the reorganization of Uttar Pradesh, Madhya Pradesh, and Bihar, where other 4 states were formed, the courts did not interfere, because ultimately, if anything has to be done, it is to be done by the political dispensation of the current day. And courts will usually lay their hands off in matters such as this, because this is not an issue either of fundamental rights or of basic structure. And I think I'm done with that. Thank you very much.
Thank you. Shruti ma'am, please continue.
Sure. Thank you, Prem. And thank you, Kannan, for a very lucid and a very articulate discussion on the issue of 370. I have been chosen as a devil's advocate today. So I will try to take you all to the side wherein the picture is not that rosy. One, I've divided my discussion into 3 parts. One being the historical aspect, second being the legal aspect, and third being the contemporary aspect. So as far as the historical aspect is concerned, Kannan started from 1947. I'll try to take you back a little before 1947 and how Kashmir as the state of Kashmir came into being and how Article 370 was incorporated in the constitution. So the state of Jammu and Kashmir has been an unresolved issue since it was ceded to India in 1947. The state of Jammu and Kashmir has got its proper shape when it was acquired by Maharaja Ranjit Singh in his Sikh confederation, and he invaded Kashmir from the Mughal Empire in the early 19th century. The administration of it was then headed over to the Dogra chief, Maharaja Gulab Singh. And at the same time, when Ranjit Singh came in and Maharaja Gulab Singh took over, the British East India Company was becoming stronger. The Treaty of Anglo-Amritsar decided the fate of Jammu and Kashmir, which was formalized in the year 1846. And it came to be known as Jammu and Kashmir became a princely state, and it remained sovereign till 1947 and way after that also. I'll just come to that as well. So Maharaja Gulab Singh bought Kashmir for 75 lakhs at that time. And that is where all the trouble actually started off. He decided to remain sovereign. The British East India Company also, by virtue of the treaty, let him be sovereign. And in 1847, when the Indian subcontinent was divided into two, India and Pakistan, the then ruler of Kashmir, Raja Hari Singh, who was a successor of Raja Gulab Singh, he decided that he doesn't want to be on either side. He wants to remain a sovereign. He wants Kashmir to remain a sovereign state, and he doesn't want to be on either side. But as fate would have it, he couldn't do that for a long time, because he was then Kashmir after 1947 was attacked by Kabalia rebels from the Pakistan side, and then he had no other option but to come to the rescue. No other option but ask India for help. But then at that time, the then Prime Minister of India, Jawaharlal Nehru, told him that he cannot help him because his state doesn't come in the dominion of India. So he has to first cede to India, and then only he can help him. So with a very ginger Raja Hari Singh decided to come with India. And at that time, and under these circumstances, in October 1947, he signed this agreement, which declared J&K as a part of India, but it will enjoy certain privileges which other states won't be. India will have complete autonomy in the subject matter related to foreign affairs, communication, finance and defense. But to ensure the state enjoys special privileges, Article 370 was added in the Indian Constitution. And the Indian government made him sign the instrument of accession on 27th October 1947. And this legal document intended for the accession of princely states and either of the two newly formed nations, India and Pakistan. It was executed by the Indian government on one side and by the rulers of each of the princely states on the other side. However, the instrument of accession executed with the state of Jammu Kashmir has been limited to the power of making law by the Dominion of India with respect of state of Jammu Kashmir only on the 4 areas as I've discussed earlier. And then came the article which we have been talking about, Article 370 of the Constitution, which came into being on 26 January 1950. And the old article related to the Article 370 was a part of Part 21 under the temporary and transitional provisions into the Constitution, which was discussed by Kannan as well. Article 370 has been controversial since its inception, as it conferred special status to the state of Jammu and Kashmir. At that time, at the time of framing of the article, Dr. B.R. Ambedkar had refused to outline the article, as it made the exceptions within the framework of a free India. The drafting was done by Gopal Swami Iyengar, who was confidant of the then Prime Minister Jawaharlal Nehru and the former Diwan of Maharaja Hari Singh. This was a little background on how Article 370 came into being. Now, coming to the aspect of how the legal position and the legal position of how the abrogation happened. I have my serious reservations to how it was done. Let's see how Article 370 was abrogated on 5th of August 2019. First, the presidential order was issued. The presidential order uses Article 371D to apply all provisions of the Indian Constitution other than Article 1 and 370, which are already applicable to J&K. The concurrence of J&K government is necessary to effect such a step, but since J&K is presently under president's rule and has no state government, this was effectively dispensed with. Second, when applying provisions of Indian Constitution to J&K, the president effected one modification to Article 367. Article 367 is the interpretation clause of Constitution. In Article 367, the presidential orders inserted a new subclause 4D, which states that the words Constituent Assembly in Article 373 must be read as Legislative Assembly of the state. What does this mean? The government has sought to overcome the problem of the Constituent Assembly not having abrogated Article 370 by requiring the Constituent Assembly in Article 373 to be read as a J&K Assembly. By doing so, it now became possible for the J&K Assembly to do what the Constituent Assembly did not. That is, recommend the abrogation of Article 370. To be clear, the President has not amended Article 373 itself because he does not have the power to do so. He only can modify other provisions of the Constitution when making them applicable to J&K. Thirdly, applying this new interpretation of Article 373, the President could have abrogated Article 370 upon a recommendation to this effect being made by J&K Assembly. But since the J&K Assembly is now a UT, and this under President rule has no legislative assembly at the moment, it fell upon Parliament to make this recommendation under the new modified Article 373. Accordingly, the recommendation to the President abrogate Article 370 was issued by the Home Minister through his resolution. Through these three steps, the government calculated that it has finally paved the way for scrapping Article 370. Were alternatives available? Yes, but these would either have required the concurrence of J&K properly electing representatives to intervene, or 2/3 majority in Parliament to effect constitutional amendments. The government would, it had calculated that it would not be able to achieve this. Hence, this sort of a jugglery was done, and in a haphazard manner, the article was abrogated. The government action is, from a legal standpoint, very clever. But how clever is that? The President does not have, firstly, the President does not have the power to modify Article 370 itself. But that is precisely what the presidential order purports to do indirectly. Article 370 is already applicable to J&K under Article 371C. Under Article 371D, the President has the power to modify and apply other provisions of the Constitution to J&K. That is, provisions other than 370. By modifying Article 67 as it applies to J&K and requiring the Constituent Assembly in Article 373 be read as J&K Assembly, the President has attempted to indirectly amend Article 370. Therefore, the Indian Constitution, as is applicable to J&K today, now has two provisions that says contradictory things. Article 373 says that a Constituent Assembly of J&K can recommend the abrogation of Article 370. Article 367 4D says that Constituent Assembly must be read to mean J&K Assembly. Which provision actually prevails? This is where the government is likely to actually encounter problems. But the President has exceeded the confines of the power delegated to him under Article 371D, which is actually settled in the Kannan Bharti case, which we all have read 10,000 times in our lives at least, being lawyers. That the basic structure doctrine.
There is a few minutes, 3 minutes remaining for the conclusion.
Yeah. I'll just conclude. So, the basic structure doctrine, which has been enshrined in Kannan Bharti case, that is, a constitutional functionary cannot use the power given to him under the Constitution to do so, to which the Constitution never intended for him to do. And I will be closing my argument with the fact that, I'll pick up where Kannan has left, that these provisions are temporary. And so the reason they are temporary, they can be taken care of and scrapped whenever and whichever way, which is not true. Because in 2018, Kumara Vijayalakshmi Jha versus Union of India, 2017 matter in Supreme Court, it has ruled that Article 370 is required permanent feature. It is no longer temporary. it is required permanent feature in the Indian Constitution. Similarly, in State Bank of India versus Santosh Gupta, Supreme Court gave the same ruling a permanent feature. So, so saying that it was temporary in nature is again eyewash. And I think I will conclude by just this.
Okay, Kannan, you can counter the arguments. You have 5 minutes for the countering.
Yeah. Sorry. There was some technical glitch at my end. I was just opening the Santosh Gupta case. Yeah. So I'll just have 3 points to make. One is, can the act of the president in issuing the presidential order of 5th August 2019 be construed as an amendment to the constitution itself and therefore impermissible? See, undoubtedly, it is not an amendment, but I quite appreciate the argument made by Ms. Agrawal that you are seeking to insert subarticle 4 in Article 367, and to that extent it's an amendment, and therefore it is impermissible for the president to do so in exercise of his powers to issue a presidential order in terms of subarticle 3 of 370. Now, I'll tell you something. What in fact had happened was, when the 1954 presidential order was issued in respect of the application of the provisions of the Constitution of India to the state of Jammu and Kashmir, all the articles that were either specified in the presidential order, and as a matter of fact, Article 35A, if I today open this Constitution of India Bare Act, I will not find Article 35A in this. I will find Article 35A in the presidential order of 1954. Therefore, to state that the act of the president in issuing a presidential order amounts to an amendment is fortified by the fact that this has been happening since 1954. See, there's only one catch. When the 1954 presidential order was issued by the then President Dr. Rajendra Prasad, the Constituent Assembly of the Jammu and Kashmir was in session, because, as you know, the Constitution of the Jammu and Kashmir came into existence only in 1956. So therefore, the proviso could be given complete effect to, because of the fact that the Constituent Assembly of Jammu and Kashmir was in season. However, in 2019, the Constituent Assembly of Jammu and Kashmir was not in existence. And therefore, the only route available for the government was to apply the presidential order in such a manner as to interpret Constituent Assembly as the governor of Jammu and Kashmir by inserting subarticle 4 in Article 367 itself. And therefore, I see nothing wrong in it. The second point that I would like to make is, when Ms. Agrawal was giving the historical background as to how Jammu and Kashmir treated itself to be a sovereign in respect of its territory. And therefore, it is in these circumstances that these special, however, temporary provisions were enacted in respect of Jammu and Kashmir. Let us understand, and this I would rely upon the Santosh Gupta case that my friend referred to precisely make this point, that Jammu and Kashmir, when it acceded to the dominion of India, never considered itself to be a sovereign authority outside the sovereignty of the government of India, number one. And that is so recorded in the judgment of Justice Nariman. And secondly, if we will see the judgment in its entirety, it says that Jammu and Kashmir was and shall always be an integral part of India. And secondly, it says that when 35A was introduced in the constitution in respect of Jammu and Kashmir by way of the presidential order of 1954, it did not postulate or contemplate a separate citizenship for the people / residents of Jammu and Kashmir, but all it sought to achieve was that any law made in Jammu and Kashmir, whether in existence or to be made by the state assembly, would not be challenged. See, the reason why Article 35A was introduced under Part 3 was because you could not challenge any law made by the state legislature of Jammu and Kashmir on the ground that it violates Part 3. So to that extent, it is important why this was given in the form of Article 35A under Part 3 itself. But the judgment of Justice Nariman is very clear that Indian Constitution, neither the Indian Constitution nor the Constitution of Jammu and Kashmir ever contemplated sovereignty of Jammu and Kashmir outside that of sovereignty of the Indian government. Secondly, Article 35A did not contemplate any dual citizenship or citizenship in respect of the subjects of state of Jammu and Kashmir. And thirdly, I think there is one reference, I think it says, which is I think very heavily relied upon. It says that the proviso that the presidential order cannot ever make Article 370 inoperative because it can never be done without the consent of the Constituent Assembly. Let me just say one thing that is reflected here in para, I think 48 or something. See, that is the judge is just quoting the provision as it is to state what the proviso is. The subject matter of controversy before the Supreme Court in State Bank of India was Santosh Gupta was whether the SARFAESI Act, which is the Securitization Act of 2002, would be applicable in respect of the state of Jammu and Kashmir. The High Court of Jammu and Kashmir, a single judge, had taken a bizarre position that SARFAESI Act can never be applicable because it's a state subject. Because he said SARFAESI is an issue relating to property, and therefore the state legislature has the exclusive domain to legislate upon it. But unfortunately, SARFAESI is not a property-related enactment or a legislation, but it is a banking-related legislation, and therefore it falls within entry 45 of list 1, and that is the controversy which was settled by State Bank of India versus Santosh Gupta. Firstly, it did not ever say that Article 370 had acquired permanent status. All it said in para 48, 46 something, that the proviso, the power under sub-article 3 can never be used by the president without the concurrence of the Constituent Assembly. It is just one statement which is made.
Sorry to interrupt, Kannan. Your countering time is exceeding.
30 seconds. I'll conclude.
Okay.
30 seconds. That the president cannot do it without the concurrence of the Constituent Assembly. It is just a statement made in the passing on the exact construction of Article 370, sub-article 3 thereof. The list before the court was not whether the government through the president could decommission or de-operationalize the effect of Article 370 insofar as it relates to the state of Jammu and Kashmir. And therefore, I believe that this has got no presidential value in respect of the case at hand. And thirdly, that's my last point. Question is, it's not a purely legal question, but the question is whether the government of India ought to have taken the consent. I think that is the burning issue. Whether the government could do this all by itself unilaterally without taking the state government or the political will of Jammu and Kashmir into confidence before doing something. Let us appreciate one thing, that if there was any scope for a consultation or any consensus to be reached, I don't think the government would have done this in the manner that they have done it drastically. On August 5th morning, we know that this has happened. See, I think the positions were so hard on either side that there was no question of taking anyone into confidence. The cleavage of opinion between the two sides was so vast, so diverse, that I don't think we'd be fooling ourselves if we think that there is a possibility of taking consent of the Jammu and Kashmir political will before the government of India did something. And ultimately, I think it's a political decision that the government has done, based on which it got the mandate and it came back to power. And I think that's what I would say. Thank you.
Okay, so Shruti ma'am.
First of all, I would begin with the issue of sovereignty. Jammu and Kashmir, the fact that they had their own penal code, Ranbir Penal Code, which was formulated by T.B. Macaulay in 1932, it continued to be the penal code till 5th August 2019. So, and most of the laws, as we all know, are not applicable, were not applicable to J&K specifically. And now coming on to a larger issue of the aftermaths of abrogation of 2019, where Kannan has left, Amit Shah, the Home Minister of our country, when, during the parliamentary debate of Article 370, he said that the way and the manner, why was Article 370 been abrogated? He said that it was coming in way of the development of the valley of Kashmir specifically. And moreover, he said that it resulted in discrimination. And after the abrogation, this will put an end to terrorism, and it will also pave paths for education reforms, etc., etc., etc. It has been an year since this was done, and we see that it was the claims made by Mr. Shah is far from reality. The leaders, the leaders of the valley, or rather the entire state, were put under house arrest, and they continue to be in that house arrest for 6 months. Even and organizations like Amnesty International, they were critical of what was done. They said it was a revolving door detention. The practice of repeatedly issuing detention orders was against the human rights, and this is a way to circumvent the fair trial stage ground of justice system and undermine accountability, transparency of the government. So we saying that it was done. It was done, though it was done in a drastic manner, but it was the right way of doing it, and there was no other way of doing it. I have my doubts. And also there have been voices. The education system is, the schools are closed even today, and there are no, the internet connection is really, it is, I don't even know whether they claim that it is resumed, but I don't think so. It has been done even today. The government has provided satellite phones before they allowed the landline phones to be operational. The satellite phones were, the amount was, the amount of satellite phones were very less. People would queue outside, and there would be 20-hour long queues to make a call. Imagine students who were here, the Kashmiri students who were, say, in Delhi or Mumbai or any of the big cities studying and have financial distress. They have no way to contact their family in Kashmir. And as per our Home Minister, this was done so that the education system and everything would kind of, it would be in a better situation, which was even worse than what it was before. So I sincerely have my doubts of how, and these are only few aftermaths which we know about, because there are many which we don't know about because it was never reported. And people who had reported, like Mazrat Hazra, the photojournalist of Kashmir, she was again put under, she was put behind bars of late. I just saw the news. So abrogation on the cost of human rights is also a question we should all think and answer about.
Okay, so thank you for your counter. Each participant has argued each other argument. So now I think we will deal with the questions. One interesting fact is more participants are in the YouTube rather than Zoom. I mean, first time I'm seeing this. So I got a lot of questions in YouTube. So first we'll go to the participant who is with us is Sanjay Sa. Sanjay, I have allowed you can unmute yourself to ask your question, or I can directly put your question on your behalf. Sanjay, I have allowed you to unmute yourself to have your question asked to the speaker. So Sanjay Shah question is, I think it's towards the Kannan. Kannan, please unmute yourself.
Yeah.
So Sanjay Shah question is, what about the role of human rights, right to life of local leaders of J&K who are still under house arrest?
And I quite see that point. See, definitely the government would do it is expected. I mean, because they have to impose upon the state of Jammu and Kashmir something so drastic as the so-called abrogation of Article 370, which gives them special status. Naturally, there is going to be a lot of dent to what the government of India is seeking to do with the state of Jammu and Kashmir. The government, we would expect that if the government is being unreasonable, we would approach the courts. And people have rightly approached the Supreme Court. And I'm definitely with everyone's sentiment on this, that I think the Supreme Court could have possibly dealt with these issues, because these issues were squarely issues of fundamental rights and violation of people's right to freedom of speech and expression, in the sense that such detention, which I think undoubtedly is illegal beyond a certain point, ought to have been dealt with the same vigor that the Supreme Court would uphold fundamental rights in the 1980s or the 1990s. And I do feel what the government is doing is subject to the political will of the government, and ultimately we may not be able to question the government directly, and that is the only reason that we have access to courts in our constitutional and legal framework. And maybe if the Supreme Court had dealt with these matters with some seriousness and some urgency, maybe these questions wouldn't have been there today.
Okay, so Malvika Avasti from YouTube, she has question. I think this also question either can answer the question. The question is, the emergency presidential rule employed in J&K in itself was temporary. One wonders what's the reason is in replacing the Constituent Assembly of the state with the President of the Union.
Who's this question directed towards?
I mean, either can answer. Shruti ma'am, Malvika Avasti has a lot of questions.
No, so I think the question is a little because it's against. It's actually directed to me. To say why, what was the necessity to change the Constituent Assembly to the President? I think Malvika Avasti ji, what is important to note is that the reference to the Constituent Assembly, because of the fact that the Constituent Assembly has now become defunct, it has fulfilled its responsibility of framing and adopting a constitution for the state of Jammu and Kashmir, and therefore has ceased to exist. So, in order to possibly give meaning to the proviso to sub-article 3 of Article 370, the government has amended Article 367 in its application to Jammu and Kashmir by saying that the reference to Jammu and Kashmir Constituent Assembly shall be the governor of Jammu and Kashmir, who acts on the aid and advice of the Council of Ministers. So what has happened, I think, see, of course, this is slightly because today when we say the government of the parliament has done it, it's nothing but the majority government which has done it. And similarly, when we say the governor of Jammu and Kashmir, who is appointed on the pleasure of the President of India, of course, it's the President who is being referred to when they say the governor of Jammu and Kashmir, and it is nothing but the union government which is in power. But that's how it is. That's the political will in order to overcome this legal question. And I think this is the way they have answered it. Now let us wait. Only time will tell us whether the Supreme Court is going to strike it down because it's brazenly unconstitutional, or it is going to uphold it.
Okay, Malvika has another 3 questions. We'll go one by one. Malvika says, should the will of the people of the state not find representation when a question regarding the identity of statehood is raised? This is a central to even rudimentary idea of self-determination.
Should I answer this?
Yeah.
Yes, I agree with what Malvika is saying, that the political leaders who were put under arrest, they were the chosen representatives of the people. So putting them under arrest, forget about taking opinions from them. Putting them under arrest itself says a lot about whether it should be, I mean, whether people who are, I mean, Kashmiri people specifically should have representation or no. I think no, because the government has just said it that they can do whatever they want, and they can put their representatives also behind bars. So the entire political system and the entire legislative system is at question here.
Okay, short response from Kannan as well. Kannan, you have to unmute now.
The will of the people, I'll tell you something. How is the will of the people expressed? In this context, if for example, since the Constituent Assembly of Jammu and Kashmir is not in existence anymore, do you think that we should have taken the consent of the state of Jammu and Kashmir through the assembly as it existed prior to 5th August 2019? And I'll tell you what the problem there is. If suppose, see, how does a legislature express its views? It shall be by parliamentary resolution C. I think those are basic parliamentary procedures, is that if the parliament or the legislature has to say something, it shall do so by way of resolutions. Now today in 2019, we had a situation where the assembly had been dissolved because neither of the political parties could command a majority in the state of Jammu and Kashmir. Neither the PDP nor the BJP. Both had a coalition government which failed after a while. And I mean, how do we expect that the state of Jammu and Kashmir would express its views or voice its opinion in respect of the abrogation of Article 370? And I don't know if we can do a referendum. Does our constitution have any provision for conducting a referendum? I do not think so. Now, how do we do it? It's practically impossible to achieve this in the current state of affairs. Maybe if there was a political party which was in majority in Jammu and Kashmir, yes, maybe yes. Today also what we are seeing, whereby 370 has been deoperationalized and decommissioned, is the will of the people as it exists in 2019. from 1954, when the first presidential order was issued, till 2019, the will of the people was that special status Jammu and Kashmir should continue in the manner provided by the Constitution and the JNK Constitution. But the will of the people, unfortunately for the people of Jammu and Kashmir and fortunately for the people of India, has changed. And it is the larger will of the people of India that Kashmir should be fully integrated within India. And therefore, I think being a political move, the government has found the most possible legal way to do this.
Okay, so the comment from Malvika Avasthi is the will of the people finds representation in the state parliament, which was conveniently suspended during this.
Right, as I already answered it, it was not suspended because of in exercise of powers under Article 356, whereby an emergency was declared in respect of the state of Jammu and Kashmir. The suspension of the state assembly happened because of the fact that none of the political parties could command a majority, and therefore what had to happen was only by way of this.
And Malvika, last question is, does this not create dangerous precedent for the federal structure of the Indian Constitution?
Shruti, would you like to do this, please?
I mean, again, I would be very colored with my view. Yes, I mean, to an extent, yes, because once this sort of a scrapping of provisions is done, then there are other states also, states like Jharkhand, states like Chhattisgarh, wherein there are internal conflicts and Maoist and Naxalite situations are prevalent. So tomorrow, the next step would be to go on setting the same precedent, doing it in states like, I mean, Jharkhand, Chhattisgarh, Nagaland. So this would be the next step. And we would be then brazenly going ahead doing this without actually taking consonance with what is of the provisions of the Constitution.
Short reply from Kannan as well.
Yeah.
A short reply.
Yeah, what I feel is, see, I'm in India, unfortunately, although I agree with the point that Ms. Malvika is making, but what I feel is that India is not purely federal, unlike the United States. And therefore, the question of will of the people of state of Jammu and Kashmir does not quite arise. And India being a quasi-federal country as per the Constitution of India, with a tilt of supremacy in favor of the union. And in my opinion, state of Jammu and Kashmir, as it existed prior to 5th August 2019, was so federal, and it was so foreign to the Indian Constitution. And to that extent, see, I mean, I understand the sentiments coming from state of Jammu and Kashmir. They've definitely lost something with the decommissioning of Article 370, because whether be it reservation or property or any other matter which Article 35A provided for, has been lost today. And of course, there is like a lot of benefit that even the rest of India has in respect of Jammu and Kashmir, because now they would have property rights there, rights to services there. People would want to settle. If you all recall, there was a time where IAS officers, judges of the Jammu and Kashmir High Court, who are appointees of the Union of the President of India, who go and serve there, and they serve their lives there until they retire. And they wanted to create a cooperative society for building some houses, and that was not allowed. When you see, these are all Indians and they are going there as per the constitutional and legal framework, and there is this special status given to Jammu and Kashmir coming in the way of these people who are spending lives there. I mean, just one instance. I mean, and we've done this for so many years, where income tax, although it was extended to the state of Jammu and Kashmir, was never implemented for so long. And to that extent, I feel that it is a right decision and we are going in a right direction so far as what has happened with the operationalization of Article 3.
I think this is a very difficult question. Sanjay Shah has the question. The question is, any comments on working of Supreme Court? I think Supreme Court is not working efficiently as expected in the case of Jammu and Kashmir after more than a year. 4G internet has been resumed, that too in some reason. Anyone can respond.
Yeah,
It's relating to the functioning of Supreme Court.
I think I've so many questions were there. I think Ms. Agrawal she's also, because she's a lawyer practicing in Supreme Court. And since it's a question squarely at how efficiently the Supreme Court is functioning.
I think we should not be questioning on how the Supreme Court is functioning, because we have a lot
with
of
the current state of affairs.
Even then, even then, I have my faith in judiciary, and I think we have a lot of very good judges who are more learned than all of us around. So, commenting on whether the Supreme Court is functioning correctly or no is, I think, very amateur a comment to make.
Okay. Any response from Kannan?
No, I'm okay. I'm okay. I
So
think
we'll
I saw one more question on the chat, I think, which is very, 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 very interesting question from Sonu. How is it fair to consider the will of only a part of the people of Jammu and Kashmir when a major part of the indigenous population has been displaced? I think that's a very, very interesting question. Now we see, if not for Article 370 and the special status given to Jammu and Kashmir, we would not have had the Kashmiri migrants issue in our country, where in their own country they had to live as migrants. They were having a very, very comfortable life back in the Kashmir Valley, and they had to be refugees in their own country, which was one of the most pathetic things that India has ever seen. And if the union government could do something, and it could not do so, it failed to do so, it did not do so, it could not do so because of this limitation that we had in the form of Article 370 and the presidential order issued pursuant thereto. And it is rightly, I mean, I would definitely say that the population which comprises Kashmir is fairly large number of Muslim population, and as far as Jammu is concerned, this is a fairly Hindu population which is there in Jammu, and we are not even considering Ladakh in this, lay in this, because they have always wanted to be a union territory, and their demand has been ongoing for several years now. And when we are talking about this issue, we are only talking about the mainland Jammu and Kashmir as it exists today in the form of union territory of Jammu and Kashmir. And I think it is a very good question to say that why should only a part of the Kashmiri population today should be heard in respect of this abrogation when the indigenous people have already migrated due to internal disturbance.
Okay. So I think they will go, if the speaker are comfortable, they can have their short answer to this. But since the participants have the question, I will repeat their question. He once again asks, sir, any comment on the contempt case? Faith in judiciary we all have, but we must have.
I think we are not on that subject.
I
will organize a lecture on contempt. We will answer that.
I just complete this. Sir, any comment on the contempt case? Faith in judiciary we all have, but we must have review for the judiciary too. I think being an advocate, we are directly responsible for the decision of the court too. Thanks, sir. So I think we are not in that subject. We are actually on the article.
We are not in that subject. Let us not.
Correct. So I think we have all done with the question. So thank you to the speaker for with this short notice. The speaker has prepared themselves. The participation was well. I was quite surprised. The YouTube has most participation than Zoom meeting, which was quite surprising. And thank you everyone. Thank you Kannan and
Thank you, Prem,
Thank you,
Begin
Kannan.
Portal.com. Thank you, Ms. Agrawal. Thank you.
Thank you, Kannan. Thank you, Prem.
Bye bye. Thank you.